17-03683, Israel Chantres Leon versus Cedric Wright.
Okay. So we're handling pre-trial right now in this case. It's set for trial tomorrow. We're going to be meeting the central jury room at 9 a.m. and we're going to deal with all our pre-trial issues that we have for the case. Have you had an opportunity to look at the defendant's motion in limine, Mr. Hendricks?
I have, Your Honor, and we've narrowed I don't think we have any in which we're going to need the court's ruling. We have in Chad.
Yes.
Would you want me to go ahead and describe my understanding of the agreements we've reached as to certain paragraphs of the defendant's motion in limine?
Sure. If the court needs them, that's fine. I think there's really only 4 out of defendant's limine that we've agreed to how they apply or not apply in this case. I'll try to do this as quick as possible. Numbers 16 and 17 are withdrawn by me, by the defendant, so long as the subject records at issue there have been proved up by affidavit and disclosed and produced in discovery. And I've been told by Mr. Hendricks those records have been, so we don't need the court's involvement on that. 19 relates to unrecoverable charges. Again, in this case, it doesn't, it relates to challenged medical bills. And so it only applies to, as we'll get into, a couple of providers' bills who've been controverted, and that they can't, talk about that evidence until it's introduced. And so I don't think it'll be an issue. And then finally, 33 relates to hearsay statements at the scene by witnesses, parties, or police officers. Again, I'm not contesting the police report or the narrative investigative comments by the police officer being contained in there. It would just be, and I'm told that's all there will be. I just didn't want there to be unchecked witness comments or police comments that aren't part of the records that we have, and I'm told there aren't any. So with that, we don't have any disputed issues that the court needs to get involved in. Did we lose you, Judge, or are you there?
Any objection to the plaintiff's motion in limine?
Yes, Your Honor, there's a number of issues we went through, and I think there's 3 that we'll submit to the court. I think the rest of them have been amended or agreed to, and to the extent Mr. Hendricks wants to put that on the record, he can. But I trust him. It's up to however he wants to.
Okay.
Handle.
All right. Your Honor, I'll mention first the 3 paragraphs that we need to submit to the court for ruling.
Okay.
First of those is paragraph 29.
Okay.
So offering any testimony or evidence concerning the necessity of the treatment rendered or the reasonableness of charges on a basis that is not set out in a properly prepared and filed controverting affidavit per the requirements of Chapter 18 Texas Civil Practice and Remedies Code. And I think we need to discuss with the court the recent Allstate case as to how that might open up the subject of paragraph 29. Chad, see, Chad,
Well,
thinks-
Your Honor, if I might, there's, I don't know how many providers, there's 6 or 7 providers. Half of them are in this case, half of them are accident injury related clinics. We've controverted those. There's some medical not controverted. The way 29 reads, offering any testimony or evidence concerning, if it's not challenged, I don't have any testimony or evidence for the unchallenged, and uncontroverted providers. My comment was, I believe the In re Allstate decision does allow there to be arguments, as long as it's reasonable, without evidence or testimony of a controverting nature, is the way the new Supreme Court decision, my interpretation of it, that hasn't really found its way through all the trial courts. So for that reason, that issue, we thought we would.
I think you're right. I've read In re Allstate, and I think you're right, Mr. Kimball, that is how it reads. So I'm going to deny that motion to eliminate. Next one.
I can move through it real quick, Your Honor. The other 2 that we were going to submit involvement from the court, they're 37 and 38. It's attorney referral to medical providers, 37, and LOP being 38. Candidly, I don't know in this case I don't know that there is or there isn't evidence of that. I don't, I believe that goes to bias, credibility.
I don't think In re Allstate or Auto Crushers covers either of those. So I'm going to grant both of those motions eliminates.
Okay, so that's all we need submitted, and unless Mr. Hendricks wants to go through our agreements, but I think we have them documented with each other.
Yep, I trust Mr. Kimball to keep our agreements as well, Your Honor, so I don't take the court's time to recite them into the record.
All right, let's go ahead and pre-admit exhibits. Which exhibits are the plaintiffs offering? You can just give me numbers.
Your Honor, I show plaintiffs exhibits 1 and 2.
That's it?
Chad?
No, there's more, but I have no objection to 1 and 2.
1 and 2 are admitted. Or are there any other exhibits?
Yes, Your Honor. Plaintiffs exhibit 3 is withdrawn at this time since it doesn't yet exist. It may come up. It's a list of medical bills, and it may be created and offered later, but not at this time. Plaintiffs exhibit 4. We have an agreement that only $550 of charges on Plaintiffs exhibit 4 are to be admitted by agreement, and then the affidavit and all other copies of attached bills are withdrawn.
That is our agreement. I haven't seen what that looks like, but that is our agreement. I'm sure it'll reflect it tomorrow.
I don't think I quite understood. What are y'all doing exactly?
So, Your Honor, exhibit 4 is UT Southwestern. It's basically Parkland's ER doctors. Unfortunately, they did an affidavit of about $6,000 that has 8 different visits, but only one of those visits is related to our accident by stipulation, by agreement. So only that, I don't mind that one bill. They proved up more than the one bill. We're going to allow the billing record, frankly, without an affidavit, without objection from me, for the one visit to come into the jury for that, and that
Okay.
totals $550.
I get it. That makes sense. Okay. 4 is admitted as redacted. Anything else?
Plaintiffs exhibit 5 is agreed to be admitted.
5 is
Correct.
admitted. You can just give me 5 through 10 or 5 through 15.
All right. So 5, 6. Let's see, plaintiff's 7,
So what about 6?
6, 8, and 14.
Are admitted?
No, they are controverted, and they need to be proved up by testimony before they can be admitted.
Okay.
So,
So 7, is it 7 admitted?
yes, Your Honor.
Yes.
7 is admitted.
10, let's see, strike that.
10 is admitted. Is that agreed, Mr. Kimball?
It is.
10's admitted.
And
11, is it admitted?
9, and, well, Your Honor, 9, 11, and 22, and 25 are withdrawn since they do not exist. So that leaves admitted 7, 10,
12 through
12 through
21.
21.
Any objection to 12 through 21?
Exception 14, yes, is not agreed to. That's something that's been controverted, but the rest of them, no objection.
12, 13, and 15 through 21 are admitted.
Correct.
And then, yes, Your Honor.
Is that
And
it?
23 and Chad, 23 and 24, we have a disagreement as to whether those.
That's right. There's no pre-admission. Yeah, we don't agree on those.
Okay.
And those
Is
are
that it?
That's it, Your Honor. 23 and 24 were not agreed on.
Defendants, do you have any exhibits of pre-admit?
Not at this time, no.
Okay. Let's talk about the jury charge. Is this going to be contested liability, or have you guys stipulated?
We haven't, we may stipulate in the morning, candidly, with the schedule, Your Honor. I think Kyle Smith in my office, when I get done here, he may be the one trying in the case tomorrow, and I need to visit with him. And so I would say, I'll know first thing in the morning, and it may be 50-50. If I think it's a case of liability. And so if that'll get us through, I think we'll stipulate, but I just needed to, I kind of wanted to verify with him before I
so
speak to it.
so we don't know if there's stipulation. What are the elements of damages we're dealing with?
Past and future medical expenses, past and future physical pain and mental anguish, past and future physical impairment, and past and future lost earnings.
Okay.
You know,
All right. And then we may have a stipulation as to liability, or you may be just, but it's not, there's not going to be comparative. It's either going to be the negligence question or just no question. Is that right, Mr.
We've
Newman?
never, yeah, correct. We've never pled that. That's right.
Any other pretrial matters we need to deal with before tomorrow?
The only thing I'll say, Your Honor, I don't know if I need to say it now, but just, I don't want it to be quiet and then there be some acquiescence. On the wages, I don't think nothing's ever been disclosed. I tried to question the plaintiff on it. He said, I don't know. They said, we'll supplement and let you know. So I've never seen a dollar figure, never seen a document.
If you haven't submitted that, then you're not getting it. If it's not in your request for disclosures, it's not coming in.
And that was before my time, Your Honor. That may well be the case. And if it is, of course, we don't get it. I agree. Plaintiff does not get issues on past or future earnings.
Okay. And is there anything in the medicals that give an amount for future medicals?
I believe there's some statements in some of the chiropractic records.
Okay. You need to have something in there, in my
Of course.
opinion, so.
Of course.
to be able to submit that. Any other pretrial matters we need to chat about?
Not from the defendant.
Nor from plaintiff, Your Honor.
Okay. Sounds good. We will see you at 9 a.m. in the central jury room.
Thank you, Your Honor.
All right. And you know, we're going to the George Allen, not the Crowley Central Jury Room.
Okay, good. Thanks for the reminder. Good.
I'll take all the help I can get. Thank you, Judge.
All right. See you. And Kyle Smith may be trying this instead of you.
That's correct.
Okay. We'll see either you or Mr. Smith tomorrow morning.
Very well. Thank you.
All right. And if the case settles, which it doesn't sound like it's going to, let us know as soon as possible.